first, why are we even talking about this topic now, and what do we mean by domain name disputes in the age of coronavirus? So the short answer to the question is that scammers are everywhere these days, trying to take advantage of consumers, and therefore also the brands and trademarks that they rely on, which means that the bad guys are doing things like sending out phishing emails, as you can see here, for fake vaccine appointments. Um, and many of those scams, of course, rely on domain names, as this Washington Post article from September noted, which quoted a report from an organization called Digital Citizens Alliance, which said, quote, as long as the number of COVID cases continues to grow, scammers and domainers will capitalize on Americans' fear and uncertainty, close quote. And that was before we even had a vaccine. So the abuses really have only been growing online. In fact, one report has found more than 84,000 recent domain name registration that contain the words corona or COVID, let alone other related words such as vaccine or ventilator, or of course, typographical spellings of these words. And granted, many of these domain names do not contain trademarks, but some of them do. And so as a result, they're targeting specific trademark owners and their consumers through what is commonly known as cybersquatting. But there really is no universal definition of cybersquatting, which is a term that was first used in the mid-1990s, as many of you surely know, before many of our clients and many trademark owners recognize the importance of the internet and the potential problems that could be caused by the registration and use of domain names that contain their trademarks. So in the early days of cybersquatting, the problem was identified as a type of trademark infringement and even trademark dilution, since the Federal Trademark Dilution Act had just gone into effect in 1995, which was coincidentally about the same time that cybersquatting arrived. But trademark laws were not entirely well equipped to address the issues created by essentially bad faith registration or use of domain names. So we saw things such as traditional trademark confusion and counterfeiting online, but also new types of online activities arose, such as phishing, spreading malware, deceptive advertising, pornography, blackmail, and other scams that prompted trademark owners to seek control of domain names registered by others. So, of course, humans have always found creative ways to get things they don't have, but using a gun to wrestle a domain name away from a cyber squatter, as one man in Iowa actually tried to get a domain name for himself in 2019, that's not a viable or legal option. And so as a result, or long before that rather, that's where domain name dispute policies arose. And these were created really as an alternative to using traditional trademark laws against cyber squatters. They're contractual policies, and especially the UDRP, or Uniform Domain Name Dispute Resolution Policy, which I'll explain in a moment. They provide uniform rules, as the name says, for domain name disputes worldwide, eliminating jurisdictional issues and offering relief in a much quicker and less expensive manner. And in particular, the UDRP, as you can see here, has proven to be extremely popular. And I'll talk in a moment just about how popular it is for trademark owners, since it was created in 1999 by ICANN, the Internet Corporation for Assigned Names and Numbers, which is the nonprofit entity responsible effectively for the domain name system. Now, as you may or may not know, a typical UDRP case can be filed for about $1,500 and is often resolved in only about 2 months, all of the proceedings taking place online with no need for expensive or time-consuming litigation procedures such as discovery, motions, hearings, or trials. The UDRP applies by contract to the .com top-level domain and most other top-level domains, which enables a trademark owner to obtain a decision ordering the transfer of that domain name, which is an order that registrars are technically required to implement. So we could spend the full hour and many more hours just talking about how the UDRP works. But in the interest of time, the most important thing to know is that the UDRP has a three-part test. So when filing a complaint, a trademark owner has to prove by a preponderance of evidence that the disputed domain name is identical or confusingly similar to a trademark in which it has rights, that the registrant of the domain name has no rights or legitimate interests in it, and that the domain name was registered and is being used in bad faith. Now, the UDRP policy itself, as well as the literally tens of thousands of decisions over the past 22 years, obviously add a great deal of detail to all the parts of this test. So trademark owners can file UDRP complaints at any of the now 6 ICANN approved service providers, the largest of which is WIPO, the World Intellectual Property Organization in Geneva. But many of you may also be familiar with the forum, formerly known as the National Arbitration Forum, which is the only US-based provider in Minneapolis, and it receives the second largest number of complaints under the UDRP. The other providers that you see listed here are based in Prague with multiple offices in Asia, also in Jordan, and most recently in Canada, although it's important to remember that they all administer the exact same UDRP policy. So trademark owners can file complaints with any of them, no matter where they are or where the alleged cyber squatter itself is located. So the UDRP has proven, as I said before, to be extremely popular for trademark owners. And the number of cases filed in recent years, as you can see, has been steadily increasing. This chart that you're looking at right now actually doesn't reflect all UDRP cases. It only shows those at WIPO. And it actually includes some cases under other domain dispute policies, not just the UDRP, but the point is still the same. It's pretty clear. 2020, as you can see, was yet another record-setting year for domain name disputes. And fortunately for trademark owners, the UDRP is serving them quite well. At WIPO, more than 88% of all domain name complaints that have ever been filed have resulted in orders transferring the disputed domain names to the trademark owners or the complainants. In a small number of cases, only about 1.5%, the disputed domain names have been canceled. And in about 10% of cases through the years, have domain name registrants or the alleged cyber squatters defeated a UDRP complaint, which effectively allows them to keep their domain names. So that's a large bit of background. And I guess, the next question to ask is, why are we seeing such a spike in UDRP complaints and other domain name disputes now? So I think there are several reasons. WIPO recently issued a press release on the topic, noting that it handled 50,000 cases through the years. And remember, that's just WIPO's caseload, not all UDRP cases, which are handled by the other providers. So the WIPO press release said that, quote, the COVID-19 pandemic has fueled cyber squatting cases, close quote. And they cited an increase, among other things, in people working from home, which I think means that more potential victims are online more often. And WIPO also referred to an increase in the number of domain name registrations in general, which I think means that there are simply more bad actors out there, perhaps trying to seek financial gain during hard times by engaging in cyber squatting. So in any event, I want to turn now to discuss a few real UDRP decisions that relate to the pandemic. The very first coronavirus specific UDRP case was for the domain name, as you can see here, coronavirusgoogle.com. Google filed its UDRP complaint at the forum for this case in March 2020, right around the time that many states and cities around the United States were starting their lockdowns. Now, one thing to keep in mind is that UDRP complaints and responses, when there are responses and other documents, are not publicly available. So really what the public can learn from UDRP cases is what are simply in the decisions, which are published online by the providers. So the decision in this case for coronavirusgoogle.com was pretty short. and came just a month after the case was filed. And it really doesn't say much about how the domain name was being used, other than it says, quote, respondent uses the domain name to pass itself off as complainant online in order to redirect internet users seeking complainant's products or services to a website that has no affiliation with complainant, close quote. So in this case, the registrant of the domain name did not submit a response, which, by the way, is not uncommon in UDRP cases, although it's also important to keep in mind that there's no such thing as a default judgment. And the registrant of the domain name actually offered, after the UDRP complaint was filed, to transfer the domain name to Google. So as sometimes happens in this situation, the UDRP panelists did not issue a substantive decision on the merits of the case, but simply agreed to accept the registrant's offer to settle and ordered a transfer of the domain name. The next UDRP case I want to focus on did not include the words coronavirus or COVID or anything similar, but it obviously related to the pandemic because it was for the domain name purellonline.com and was filed by the owner of the Purell trademark Gojo, which had found a website with the domain name that was selling counterfeit versions of the Purell brand of hand sanitizers that we all recognize, and said that the domain name was also being used in connection with a phishing scheme. So in this case, the UDRP panel easily found bad faith on several fronts. I should note that usually phishing by itself is evidence of bad faith under the UDRP. But also in this case, the panelists noted that what is sometimes referred to as opportunistic bad faith, which arises when a domain name is registered and used in connection with a specific event, which here obviously was the coronavirus. So the third and last case I just wanted to mention before I hand the controls over is one that was filed at WIPO by a British governmental entity. It's formally known as Her Majesty's Revenue and Customs, which is often shortened to HMRC. So as you can see, the disputed domain name in this case was hmrc-refund-covid19.com. It obviously contained the HMRC trademark, and as often happens in UDRP cases, it was being used in connection with a site that was distributing malware. So here, just like in the Purell case, the panelists under the UDRP had no trouble finding bad faith, and wrote that the cyber squatter was, quote, cynically targeting internet users who may already feel vulnerable and be desperately searching for some good news amidst all the suffering and disruption, close quote. So I will now let Brad take the reins, followed by Larry, and then I'll be back with some comments in a few minutes about the future of domain name disputes, and then hopefully, as we said, have plenty of time for questions. We obviously have a huge amount of content that we've covered in a short period of time already, and we're running short on time, but I want to kind of address a number of other issues. We've talked so far kind of about what the current state of cyber squatting is and how we got here. But I want to take the remaining few minutes before we have questions and answers to sort of talk about where we go from here. The first and most important thing really to make clear, if it's not already, is that registering and using and buying and selling domain names is a big business, not just for trademark owners, of course, and for other legitimate individuals and companies, but for cyber squatters. So we now actually have more than 370 million domain name registrations out there, and growing at about 3% per year. And of those, about 40% are .com domain names, which account for the overwhelming majority of all domain name disputes, including under the UDRP. But in recent years, as we sort of alluded to earlier, we've had the arrival of what are called new global or generic top-level domains, new GTLDs, and these. The arrival of these really means that cyber squatters have even more opportunities to target trademark owners. So some of the new GTLDs are especially attractive right now and fit with the theme of our program, such as .health, but a number of others with sort of general applicability are starting to appear in UDRP decisions, such as .online, .xyz, .top, .store, and .shop, just to name a few. It's also important to know that there are more than 200 country code, or CCTLDs, which granted, these are typically more popular in other parts of the world than in the United States. Every country has its own two-letter country code, such as .uk for the United Kingdom, .ca for Canada, .au for Australia, and so on. About 40 of the CCTLDs have adopted the UDRP, and many of the others have enacted their own domain name dispute policies, some of which are based on the UDRP. And I expect as more countries do adopt the UDRP, which has been happening in recent years, trademark owners will find it even more attractive to pursue cyber squatters in other regions of the world. And speaking of other domain dispute policies, I also think it's worth a quick mention that there is a competing policy to the UDRP. It doesn't get a whole lot of coverage, and that's probably, among other reasons, because it does not apply to .com or .net, which are the most frequently disputed top-level domains. But that's the URS, or the Uniform Rapid Suspension System. This was created really in connection with the rollout of the new GTLDs. It was designed to be a quicker and cheaper alternative to the UDRP, but it never really caught on. And in fact, it's actually been declining in use significantly, in part because it only applies or provides for the temporary suspension of a domain name rather than a transfer, which means it's not a permanent fix to the problem. And also, I think it's worth briefly mentioning, although it will surely be a lengthy process, there's a lot of talk, if not actual action, around what's often referred to as UDRP reform. In other words, whether the UDRP is working well and whether it should be amended or updated in any way. The truth is, it's a very political issue because any change ultimately needs to be approved by ICANN, which created the UDRP in the first place. And as you can imagine, trademark owners and domain name registrants have differing opinions on this topic. But some of the ideas being tossed around relate to some of the topics that Larry mentioned earlier, some of substance, such as whether the requirement for registration and use in bad faith should be changed to registration or use in bad faith. And some of the others, possible reforms relate to procedure, such as whether there should be a built-in appeals process to the UDRP. And so I guess just in closing, before the questions, what I would say is I always tell my clients when it comes to online scams, nothing surprises me anymore. And that's not for a long time. None of us probably would have thought a little more than a year ago that, domain names with the words coronavirus or COVID would be popular for cyber squatters, or that domain names would be used to advertise fake vaccines for a pandemic. But that's exactly where we are, which means that while I'm somewhat encouraged these days by the progress we're making against COVID, I have absolutely no expectation that cyber squatters will disappear anytime soon. So with that, I think Jason or Uma have been collecting questions, if there are any, and we're happy to stick around, even though we're right at an hour now.